All right, well, welcome everyone. We will get started. I want to say hello and good afternoon. I'm Bill Silva, Associate Executive Director at the Connecticut Association of Schools, and I want to thank all of you for joining us for today's webinar on employee discipline, presented by our distinguished guests, attorneys Tom Mooney and Natalia Sieira Millan from the law firm of Shipman and Goodwin. Before I introduce Tom and Natalia, I want to thank CAS's corporate partners, the College Funding Coach, Horace Mann, Jostens, and MCM Fundraising for their ongoing support of CAS's high-quality professional development for school leaders in Connecticut. I also want to go over how we'll proceed today. During the presentation, you in the audience are muted, but you may share any questions you have using the Q&A feature, and our presenters will try to answer as many questions as they can during the hour and a half that we have today. We probably won't get to everybody's question, but we'll do the best that we can. And we may revisit this topic or related topics in the future. We are also recording the webinar, and we will make that recording available along with the PowerPoint and other materials, make all of those available to you in the next few days, and you will receive a link if you register. And now let me introduce our presenters. Attorney Natalia Sieira Millan is an associate at Shipman and Goodwin and a member of the firm's school law practice group. A graduate of Boston University and the Quinnipiac University School of Law, Natalia was the assistant agency legal director with the Connecticut Department of Children and Families and a Connecticut State Superior Court law clerk prior to joining Shipman and Goodwin. Natalia teaches school law courses at the University of Connecticut NEAG School of Education and at the School of Education at Quinnipiac University. Attorney Tom Mooney, a partner at Shipman and Goodwin, is the author of A Practical Guide to Connecticut School Law, now in its 9th edition. In addition to his extensive practice in all areas of school law, Tom teaches at the University of Connecticut School of Law, serves as professor in residence at the NEAG School of Education at the University of Connecticut, and is adjunct professor in both the School of Law and the School of Education at Quinnipiac University. A graduate of Yale College and Harvard Law School, Tom has been widely recognized for his many notable contributions to the law and to education in Connecticut. Both Tom and Natalia are good friends of CAS, and we're very happy to have them back to provide their insights and guidance on today's important topic of employee discipline. So welcome, Tom and Natalia. So good to see you. Thank you for being here. And now I turn the presentation over to you.
Thank you, Bill, and welcome to everyone. We hope that this hour and a half will be helpful to all of you. As we have done in the past, we'll pose questions and then answer those questions to try and share with you some of the learning over the years on the best way to handle this challenging topic of employee discipline. As Bill mentioned, we don't mind questions, and if we can answer questions as we're going along, that's great. We can't get into individual circumstances. We can't practice law through this seminar, but when you have procedural or related questions, I hope that we can offer you helpful answers. So with that, I'll move right on to question 1, and Natalia and I will be trading off, and I get the first question. So here it is. I keep personal notes in my right-hand desk drawer to document my concerns with teachers and other employees. One of the teachers in my school has asked for a copy of her personnel file. Do I have to share my secret notes with her? Now, if we were all together, I would see some embarrassed smiles because I presume that most of you keep secret notes in your right-hand desk drawer about issues of concern with employees. And as Natalia will talk about in question 2, leaving them in your desk drawer is not a good idea, because if the concern is worth noting down, the concern is worth sharing with the employee. But getting to the specifics of this question, are the notes that you have part of the personnel file? Well, we start with a threshold observation, and that is that the personnel file is not the physical manila folder on the shelf, but rather the personnel file is a category of records. We have a decision of the Freedom of Information Commission back in 2006, where a teacher asked for her personnel file and they went to the drawer and handed her her file. And in later proceedings, it turned out that there were all sorts of other documents related to her employment that had not been included in the file. And she filed a complaint claiming that she'd been denied public records in accordance with her request. And the commission agreed. The commission said that the personnel file is not a geographical location, but rather the category of records related to a person's employment. Now, after the talk today, I'm sorry, I keep getting a phone call. After the talk today, you'll have access to 16 pages worth of our wisdom on these questions with citations to statute and so on. And one of the things that we've included is the definition of the personnel file from the Personnel File Act, which is not applicable to school employees because it's only applicable in the private sector. But it's helpful because it describes the nature of records that would be normally considered part of the personnel file. And that reference will be available to you. But now back to the secret notes. The Freedom of Information Law says that essentially anything that you record is a public record if it has to do with the business of your school district. But not all records are subject to public disclosure. And those of you in the audience are perhaps most familiar with FERPA, that there's records that are confidential. They're still public records, but they are not subject to public disclosure. Well, one of the categories of records not subject to public disclosure are preliminary drafts and notes. And so that really answers the question as follows. Have you kept those notes to yourself as a memory aid? If so, those notes are not subject to public disclosure. And we have a decision of the appellate court so holding some person was in a hearing and got mad when he lost and asked for the personal notes of the people who were on the panel making the decision. And the appellate court said, no, those were preliminary notes because they hadn't been shared. If you've shared these notes with others, then they're no longer preliminary. They would be subject to disclosure. And in this particular case, they would be considered part of the personnel file. As I turn it over to Natalia for question 2, I want again to make the point that secret notes in the drawer don't do anyone any good. So Natalia, question 2.
Thank you, Tom. So a paraeducator has arrived late to work 7 times, and her repeated tardiness has imposed hardship on the classroom teacher. Can I suspend the paraprofessional? So unfortunately, you can insert just about every single type of employee in this question at some point or another. I'm sure you've had to deal with a circumstance in which one of your employees has been late to work. And so the answer to this question, unfortunately, is it depends, right? So if we receive a call about a situation like this, typically we first ask whoever's on the other end of the phone, what is the employee's disciplinary history? And that is important because as we're going to talk a lot more today about sort of the appropriate disciplinary response in progressive discipline, we need to understand sort of the whole context. Like, what is this employee's disciplinary history? What have they been like? Have they been tardy before, right? Have they been disciplined for that specific issue before? So the principle of progressive discipline requires in most cases that disciplinary action follow a progression of intensity. And that progression of intensity is intended to correct the employee. And oftentimes we get into this debate with our clients around whether the discipline is supposed to be punitive in nature or corrective in nature. And it's our firm belief that, that discipline generally is intended to correct the employee, and if possible, unfortunately, ultimately permit the termination of that employee if that conduct persists, right? But in the first instance, we want to make sure that we support the employee to correct and rectify the situation. So the first step in progressive discipline is obviously notice. Has the employer made expectations clear to the employee? In other words, have we told employees that it's absolutely critical that they arrive to work on time? I suspect the answer to that is yes. And so we can foresee a situation where some expectations are implicit and we don't need to tell them, right? It's clearly outlined in everyone's expectations that people must arrive to work on time. And another, easy circumstance where something is implicit is you shouldn't steal or you shouldn't assault your colleagues. But in cases where notice is required before an employee can be held accountable through discipline, it's very important that we keep this notice requirement in mind. And that is because we need to tell employees that this is the rule. If you violate the rule, you're subject to discipline, right? And that's just part of due process and fairness in general. So in this circumstance, we would ask whether the employee has been told that her tardiness to work is unacceptable. And until that happens, whether the employee has been late once or 20 times, discipline is likely not going to be sustained. And that's because of that principle of fairness. We want to make sure that they are on notice that what they're doing is not appropriate and is inconsistent with the expectations of their supervisor. So the first level of discipline is the easy one, right? We talk about oral warnings all the time. And so with respect to oral warnings, there's always a question of documentation. Typically, we don't record oral warnings because people just simply remember that they were told, you should not be late any more times. But there are times in which some school districts decide to sort of follow up with an email and say, just want to document our conversation today in which you receive an oral warning with respect to this conduct. You were late today. This is now the second time that you're late. And so you're now receiving an oral warning for your misconduct. So, but in any event, oral warnings are the lowest level of discipline. And then we move on in sort of traditional progressive discipline with a written warning. And such type of discipline typically reduces the employer's concerns to writing. And it's very detailed, and we provide a very specific notice of what is wrong, what conduct is alleged to be a problem, right? Or actually confirmed to be a problem, I should say. And we give that written warning to the employee. Sometimes those written warnings are subject to collective bargaining provisions. Some of you that may be involved in negotiations and are at the bargaining table may have seen that there are requirements that employees sign off or acknowledge receipt of somebody providing them the written warning. And then there are other provisions that require that things be removed from the personnel file after some period of time. I know a district where the paraprofessionals can be disciplined for obviously anything under the sun, like anybody else could be disciplined, but their personnel record is expunged after X number of years, 2 years or 3 years after the incident. So unless, of course, there's a reoccurrence of the misconduct for which they received the written warning. So these are collective bargaining implications that sometimes we have to consider as we decide what to do with an employee. So after we move forward from the written warning, if the employee fails to correct the misconduct, right, his or her actions in the past, in this case being late, we may want to give the employee another written warning. But sometimes we don't even want to go there and we just want to go straight to the penultimate step, which is suspension. And so any suspension has to be accompanied by a written explanation of the reason for the suspension. We have to clearly outline why they are being suspended. I'm sure you're probably sick and tired of seeing these letters by now, but they outline sort of the misconduct that the employer has identified as inappropriate and intolerable. And the writing clearly states that recurrence of the problem is going to result in further disciplinary action. And what we like to do is to include sort of this horrifying language in there, which I think it provides enough notice to the employee that any subsequent action and any further sort of situation in which these actions recur, in this case being late, can lead to serious disciplinary action up to and including the termination of employment. So as you know, once we get to that point and the final stage in the progressive discipline, of course, our last resort is termination of the employment of the employee. And so through progressive discipline, we go through these steps. But there are sometimes circumstances in which the misconduct is so serious that we skip those steps. And oftentimes in collective bargaining agreements, the provision for discipline contemplates that and clearly says that somebody can be suspended or even terminating depending on the facts of the circumstance. So as we like to say, we need to ask ourselves whether the punishment fits the crime. But typically speaking, we're going to follow a traditional level of progressive discipline. So the last thing I want to just touch upon, which is a subject that's a sore subject for a lot of us that deal with employee disciplinary matters, is this sort of big, bad, just cause provision that contracts have all the time, right? And most collective bargaining agreements provide that any disciplinary action may be taken only for, quote, just cause. And there are, we see these elements of progressive discipline in the principle of just cause. And there's this traditional 7-step test for just cause. And as Tom mentioned, you're going to receive hopefully a very helpful package that is 16 pages long that outlines all of them, but it includes things like, was the employee forewarned of the consequences of his or her actions? In other words, was the employee told that if they did it again, this would happen, right? Are the rules, in this case being not being late for work and being timely for work, reasonably related to business efficiency and the performance of the employer might reasonably expect from the employee? Yes, right? So you go through this series of this 7 test question to determine whether or not there was just cause for the action. So the last thing I'm just going to say is whether an employer can show compliance with those 7 expectations is going to be critical in establishing whether or not there was just cause. So we just want to be careful as you're considering disciplining somebody, especially in a traditional progressive discipline model. You want to make sure that you're following every step and that you can answer affirmatively with respect to every question. So with that, I will turn it over to Tom for question number 3.
Thank you, Natalia. Before we get to question 3, I wanted to talk a little bit more about just cause and discipline and share with you one of the disappointments that I've had over the years in working with school districts. As you might imagine, as the lawyers, we get the call, and typically it's from a supervisor who's frustrated. And he says, do we have enough yet? Do we have enough yet? Can we fire this person? And it's important always to keep in mind that you're there to help a person until you've made the final decision. And what happened in this lengthy, it was over 20 days long, teacher termination hearing, we found out on day 20 that the superintendent had called the union in the middle of the progressive discipline or the progressive support plan and said, this teacher is too dumb ever to improve. Why don't we just cut a deal? And the arbitrator ruled that every decision made from that point forward was undertaken in bad faith. So it's, and we lost, as you might imagine. And so as you engage in this process of progressive discipline, it's very important that you keep your focus on supporting the individual and helping him or her improve. And only when those efforts have failed do you start talking about termination. And if your goal in progressive discipline is to document and justify your ability to terminate, that's going to be a problem. So I just wanted to share with you the importance of your mindset. And your mindset in imposing progressive discipline is to help the employee improve. So now, question 3. I put one of the teachers I supervise on a performance improvement plan. But when we meet to review his progress, the union representative keeps interrupting and answering for him. Can she do that? And in a word, no, she can't if you don't let her. Specifically, you have to understand that union representatives are there to support their employee. And if you let the union representative take control of an investigatory interview, you're going to be impaired in your ability to hold an employee accountable. They have training. I think of union reps in these meetings as Secret Service agents ready to throw their body in front of the bullets coming at the employee. And if you'll let the union rep will answer all the questions. But that's simply not the way it works. To take a step back, the right of union representation has been around for over 40 years, close to 50 years now. And that derives from the National Labor Relations Act and the right to collective activity. Back in 1973, the NLRB, the National Labor Relations Board, ruled that the right to collective activity for employees includes the right to have representation at an investigatory interview. The concern, and some of us remember the movies from the 30s where the police have the guy in the chair and they shine the light in his eyes and give him the third degree. The right to union representation in an investigatory interview is designed to protect the employee and make sure that the investigatory interview is carried on in a fair way. So the union representative fulfilling his or her responsibilities has the right to interrupt only to clarify a question and to make sure that the union member being interviewed understands the question and has an opportunity to answer the question fully. The union representative does not have the right to answer for the employee, and sometimes it's necessary to just stop, reset, look the union rep in the eye and say, I don't care what your theory of education is, I want to hear from the employee. And so if you want to caucus, go ahead. But when we're ready with a question, you're going to have to, the employee is going to have to answer the question. You should be quiet. The right to caucus is an absolute right. And it's interesting sometimes in these interviews to see when the employee rep decides to caucus. Sometimes you'll ask a question and the employee will give an outrageously unpersuasive answer to the question. And the tip is often the union rep says, could we caucus? And then the employee comes back afterwards, fully coached, and gives a much better answer. We may not be pleased to have the employee coached in this manner, but that is the part of the right of union representation. So those are the only two things the union rep can do. And it's important to remember that the right to union representation is not like a Miranda right, you know, from watching TV, that when you get arrested or when other people get arrested, the police say you have the right to remain silent. And it's an affirmative obligation imposed upon the police by the Supreme Court decision in the Miranda case. Union representation, by contrast, is something that employees have to invoke. They have to say, hey, you know, I don't like the way this is going. I'd like my union rep here. And at that point, it's important not to be impatient and not to say, oh, I just have one more question, and try and dissuade the employee. It's a right that they have. When they say, I want a union rep, you have to stop asking questions and wait until the union representative can be scheduled into the meeting. That all said, so we don't have an affirmative duty to warn employees of the right to union representation. But many school districts do that nonetheless, and it's advisable to do so in many cases, because if you have a meeting scheduled where you're going to talk to an employee and the employer says to the employee, you have the right to union representation, that's punctuation. That's a warning to the employee that this is a serious matter and that he or she would be well advised to have union representation. And the final thing I'll say on this is that if we set the ground rules, union representatives will cooperate, they understand. And ultimately, involving a union representative in a disciplinary matter can be very helpful. Quite often employees indulge in the defense mechanism, they're picking on me or whatever. And when you confront an employee with misconduct, in front of the union rep, and the union rep takes them out in the hall and caucuses with them, quite often the union rep can help that employee understand that this is serious and the employee has to address the concerns. So when I talk about the right of union representation, I do want to emphasize that the union rep can be a helpful person, but only if we make sure that the union rep's actions are restricted to the two issues of clarifying questions and caucusing to counsel with the employee through the investigatory interview process. So with that, I'll turn it over to Natalia for question 4. And I see that so far we have no questions from the audience, but if something comes to mind, please let us know.
Thank you, Tom. So I have the distinct privilege of having to answer the most complicated question in our section here today, and that is because it's a Title IX question, and it's, as some of you may have struggled already through Title IX, and it can be particularly gnarly. So question number 4 reads as follows. A teacher filed a sexual harassment complaint alleging that a colleague has been checking her out. I interviewed the complainant, but when I scheduled an investigatory meeting with the alleged perpetrator, his union representative told me that I had already violated his rights under Title IX. Really? So the honest answer is it depends. And I know that's one of the answers that you all dislike very much because it doesn't give you a lot of clarity. But let me see if I can sort of shed some light as to why the answer is it depends. But before we even get to the answer, let me just briefly discuss and sort of review the new Title IX landscape and the related obligations that it imposes on school districts. So you may remember that back in 2020, even though 2020 and 2021 and starting to feel like 2022 as well, is all a blur and all we think about is COVID, there was this US Department of Education release of final regulations regarding sexual harassment under Title IX of the Education Amendments of 1972. And until May 7th of 2020, there had been no binding federal regulations related to this topic, only administrative guidance issued by the Department of Education's Office of Civil Rights. And so those May 6 regulations became effective and binding on August 14th of 2020. And since that time, as we've expected, there have been significant impacts on the manner in which educational institutions investigate and address these claims of sex discrimination and harassment, whether it be in the workplace or whether it be among students and so on and so forth. So the first thing we want to know is that the final regulations considerably expanded the requirements for Title IX grievance procedures. And so upon receiving actual knowledge now of a sexual harassment complaint, the school districts have to engage in specific steps. And we've outlined those steps in that 16-page document so that you don't have to take copious notes if you don't want to at the moment. But the first part of the process is explaining to the complainant the process for filing a formal complaint. And hopefully by now, most school districts have implemented a new Title IX policy. If you haven't, this is the time to do it. Feel free to reach out to your legal counsel for further suggestions, but it's important that we do have up-to-date Title IX policies to be able to address this. We've created several model policies and several model sort of standard forms to help our clients in the process. So please do reach out to your local counsel to address some of these questions. But the first part is explaining to the complainant the process for filing the complaint. And typically the Title IX coordinator does that. The second part of the process is that we offer supportive measures to the complainant. And then we go through a series of sort of analyses as to where it is that we are in the process. Do we consider if administrative leave for the employee that's respondent is appropriate? And then do we have a formal complaint or do we just have a conversation? And once we have a formal complaint, we have to determine whether we have Title IX jurisdiction. And there are some very intricate questions that we do need to ask throughout this process. So do make sure that you're up to speed on all of the new Title IX regulations and that your district has in fact received the training that you're required to have. And so through the new process, there's also an opportunity for an informal resolution. Then we have to conduct an investigation. And in all of this, there's the whole concept of providing both parties enough due process. So we need to provide parties with the opportunity to review the evidence. We need to give parties enough notice. We need to draft an investigative report. We need to, the parties can submit written questions. And then there's this determination of responsibility and a right to appeal and so on and so forth. So it's a very prescriptive process. And so we do encourage you that to sort of familiarize yourself with the process if you haven't already. But to go back to our immediate question, which is, have we violated this employee's rights? In analyzing the question, we have to first ask whether the school district knows if the teacher filed a formal complaint. That is a critical question that we need to ask. If the employee hasn't filed a formal complaint, then a Title IX coordinator may wish to file their own complaint, depending on the severity of the allegations. And the facts of each case are significant, and some allegations may not give rise to this new standard under the new regulations, which is the conduct has to be severe, pervasive, and objectively offensive. And that is required under the new regs in order to constitute Title IX harassment. So if the employee has filed a formal complaint, the district will most likely commence the Title IX investigation and has to give the respondent and the complainant all the due process rights to which they are entitled under Title IX. But then one of the most critical parts of the process is sort of this procedural due process that everyone's entitled to, particularly the respondent, right? So one of the first requirements is that within 10 school days of receiving the formal complaint, you have to provide the known parties with written notice of the allegations that potentially constitute sexual harassment under Title IX, and they have to receive a copy of the grievance process so that they understand how to navigate the next steps. And the notice has to include things like the identity of the parties, the conduct that allegedly constitutes sexual harassment, the date and location of the alleged incident, a statement, and so on and so forth. So they're very, very prescriptive in terms of what you need to provide in that initial notice. But then another tenet of due process, which is codified in Title IX, is this whole notion that parties have to be given an equal opportunity to talk about the allegations currently under investigation with the investigator. And we have different names for different people involved in the process. But the other second critical piece of the process is that the district is required to provide this written notice to the respondent of the date, time, location, the participants, and the purpose of any meetings or hearings or interviews, and give that person sufficient time to prepare to participate, right? So here we must ask whether the district provided written notice of the allegations against the employee, and whether it also provided written notice of the date, time, location, the participants, and the purpose of the meeting for which he was being noticed, and whether he had sufficient time to prepare. So arguably, if the district in this case failed to do so, the district may have in fact violated this employee's rights under the new Title IX regulations. So they're very complicated, very specific. And so we do recommend that you work closely with your legal counsel to determine the appropriate steps in each instance in each one of these complaints. So Tom, I'll turn it over to you for question 5.
Natalia, just before you go ahead, we did have a question about Title IX asking if it applies to the example you talked about was teacher to teacher. Does it apply teacher to student as well?
Yes, and it's complicated by the teacher to student scenario, and the procedures are slightly different and similar. And when I say that, not to be confusing, but also to sort of share that in the context of students, we can't just remove them from a classroom, right? And when we talk about the employment context, we can make a determination that the employee can go on leave during the pendency of the investigation. With students, it's a little more complicated, and we need to sort of determine whether there's any immediate harm and so on and so forth. So it is very, very prescriptive, and it does apply in the context of the students as well.
Okay, thank you. And Tom, we had a couple clarifying questions to a previous question that you answered
Yes, I
about
see them.
union representation.
Yes, I see the three, and they're really good questions. And before I jump into question 4, I'm happy to answer them. The first is, can we request a UniServe rep? This would be in the teacher context, as opposed to a union designated teacher rep. And the answer is yes. In fact, who the union rep is quite often the subject of conversation. Whenever a school district says we'd like the UniServe rep here, makes that request, I would expect the union or the association to be very happy with that request, because as I mentioned, the UniServe reps go to camp and they learn how to defend employees. The local teacher rep quite often is not as sophisticated. But the more challenging question comes up with the reverse, and that is the union says, well, the UniServe rep will be available 2 weeks from Tuesday. So what do you want to do? And in that case, the right is to a union rep, not the union rep. But we would typically cooperate with the union. If they're reasonable, we'll be reasonable. If they're unreasonable, we'll insist on something more timely than 2 weeks from Tuesday. The next question is, we have teachers who are not in the union. Who is it best to ask for a list of union members, HR, the union? Well, we go back to the threshold question of the right to union representation is a right that employees elect, and we don't have to affirmatively provide that. Interestingly, though, unions have a duty of fair representation for all members of the bargaining unit, including non-members. So when we have a situation involving the discipline of a non-union employee, and we think it might go to termination, interestingly, that non-union employee can file a grievance under the collective bargaining agreement. So although I'm reluctant to give generic advice that applies in all circumstances, in some circumstances, even though a person's non-union, we would want to alert the union to that concern, and then leave to the employee the right to invite the union rep to the meeting or not. The next question is, how does progressive discipline differ from a new employee that yet is showing some concerns? And I greatly appreciate the question because it's an important part of the picture that I didn't address. And that is that this notion of progressive discipline and just cause applies to employees in normal status. But many collective bargaining agreements have a probationary period where people can be terminated without just cause. And given the labor shortage, we don't want to be too quick to terminate. We want to try and rehabilitate and improve performance and save people. But there is no burden of proof on a probationary employee. And then we get to the teacher context. And if the teacher is new to the district and is not previously tenured, that teacher is considered probationary for 4 years. If they've had tenure in the previous 5 years, they're probationary for 20 school months. And the 4 years, I meant to say 40 school months. So in those circumstances, we have the right to non-renew for any reason, any reasonable reason. And although we're not subject to progressive discipline per se and warnings of termination, that employee has the right to ask for a hearing if he or she is non-renewed. And it would be important in such a non-renewal hearing to explain that there was a rational basis for making that decision. It doesn't need to rise to the level of just cause, but it can't be arbitrary or capricious. And finally, do non-tenured teachers have any union representation? And the answer is absolutely. In fact, the law was amended to provide that DSAP holders are members of the teachers bargaining unit we negotiate special conditions of employment for them. But non-tenured teachers certainly have the right to union representation. And I think this question was partially answered previously when we talk about the unique circumstance of the non-tenured teacher. We would advise that with a non-tenured teacher, you follow the normal process of notice and discipline, but at the end of the day, you're not going to be subject to a just cause standard if the non-tenured teacher does not show the requisite improvement, and the non-tenured teacher would then be subject to non-renewal. So those, I appreciate those questions, and I'll move on to question 5. But feel free to interject those questions as we go along. So question 5, I hate writing employees up. In fact, I wish we were in person. I'd ask for a show of hands. Who enjoys writing disciplinary letters? I would think it very few, and those who enjoy it would probably be subject to some sort of psychological evaluation. But nonetheless, it's an important responsibility. And what we'd like to do in this question is make it easier. So the question is, what can I do to make it easier for me to follow up with employees who need straightening out? And as part of this talk, we'd like to share some model letters with you. And the first, if I could ask that the slide be advanced, the first is a follow-up on a disciplinary matter. And this is in the printed materials that you will have access to. So I'll just make some brief comments. When we meet with a teacher to share disciplinary concern, it's important that that be documented because if it's not in writing, the union will likely claim it didn't happen or you were lazy and it wasn't that important. So this document is intended to serve as a template. If you can get into a routine of following up on disciplinary issues with a follow-up memo every time you meet with a teacher, you're going to be better off. So the template goes on to say, to follow up on our conference, I wish to summarize our discussion and my understanding of future steps. In the template, you would then describe your concern. In your template, you would then pin the teacher down. Did the teacher agree that he has a classroom management problem? Or did the teacher disagree and say, you're picking on him and he doesn't think he has a classroom management problem? Documenting the teacher's position is going to be helpful either way, because if he says, yes, I do, then we're all on the same page, and then we see if the teacher can improve. If the teacher denies the problem, and in a subsequent proceeding, we can show that there was a problem, that teacher is not helping himself, because if the teacher won't acknowledge the problem, an arbitrator on review will not be inclined to give that teacher more opportunity because the teacher is not taking advantage of that opportunity. So then the next part of the template is, we agreed that you would, and this is important. I wish I could see in person, but 173 people here. I would say almost all of you are kind and supportive. And when a teacher or other employee is having difficulty, you want to step forward and help. So typically we see, oh, I will do this, I will do that. And then when the supervisor doesn't follow through, then the teacher says, well, you can't really hold me accountable if you can't hold yourself accountable. So you see in the template that we always want to frame this, the next steps, as what is going to happen, what the teacher is going to do, not what the supervisor is going to do. And we also want the teacher or other employee to have the responsibility for reporting back. We don't want to say, I will follow up with you next week because something will happen and you'll forget. So those are the essential elements of this template. The key being, we want to pin the teacher down, and we want to make sure that the burden for next steps is on the teacher. So then we get to disciplinary letters. This is more of a codifying or documenting disciplinary meeting. But we sometimes write disciplinary letters. And those disciplinary letters, we have two models, which are intended to show the progression that Natalia referenced. So if I could ask to advance the slide to the warning letter to Tom Teacher, my favorite teacher. Every disciplinary letter should have certain components. And let me caution you from ever sending a warning letter or a reprimand to a teacher without first talking to the teacher. You could have a teacher on warning about tardiness, and you could with your own eyes see the teacher walking in 20 minutes late. And it would be all too easy to go to your desk in an indignant rage and write up that teacher. And then you find out that the teacher's dog died or worse. And you look like you were just gunning for the teacher. So whenever you have a concern, sit the person down. I keep saying teachers, but this applies to all the different employee groups. Sit them down, say, this is my concern. I saw you walking in late. What do you have to say for yourself? Hear what the teacher or other employee has to say before you make any conclusions as to disciplinary action. So the elements here, we see allegation. We discussed a report that you'd left your 7th period class unattended. What did the teacher say? Well, I asked Mrs. Smith to keep an eye on the class so that I could go get a donut. So that's the teacher's explanation. And as this experienced group knows, that's not a satisfactory explanation. So there's a disciplinary consequence. The letter goes on to find that the conduct was unacceptable, explain what should have happened, and then warn about future situations. And whenever we write a letter like this, it's helpful, not essential, to show CC personnel file so that the teacher knows it's a part of the official record. And whatever collective bargaining provisions you have that deal with disciplinary letters, you need to follow them. Some collective bargaining agreements require that the teacher sign to show receipt, but not necessarily agreement. So be aware of whatever your collective bargaining agreement provides. And you see at the end, any future failure to meet your professional responsibilities will result in further disciplinary action. That word further is really important. Quite often I'll see a letter and then it ends with, if you do it again, you'll be subject to discipline, which in a way says that this letter is not discipline. So you always want to talk about further discipline to clarify that this letter is part of the progressive discipline chain. And then to show the progression to more severe warning, if I could turn to the next page, this is a disciplinary letter. And you see the first is called a warning letter. The next is a disciplinary letter. That's not really precise. These are both letters of reprimand, but as you'll note that this letter involves a suspension because the problems have continued. And we again see the allegation. There was an altercation in your class and you weren't there. We now, part of the progression is that the principal is not handling this. This is now the superintendent. We document how the employee defended the situation. And then we make judgments about the situation, holding the teacher accountable. It's serious. This teacher is suspended for 1 day for again leaving his class unattended. And the letter of reprimand will be included in the personnel file. And then the last sentence is important. It provides that any future misconduct will lead to further serious disciplinary action up to and including a recommendation to the Board of Education that your contract of employment be terminated. Sometimes we come into disciplinary situations and there hasn't been that progression. And in fact, I've had administrators say, well, we think we need to fire this guy. And I often ask in response, well, did you tell him that yet? Because if you haven't warned a person that there's employment is at risk, it's a stretch sometimes to move straight to termination. Although, as Natalia said, some things we skip the progressive discipline and go right to termination, but that would be a very serious situation indeed. So we hope, and this will be in the materials, but we hope this illustration of this, how disciplinary letters should be phrased and structured, is helpful. And the last thing I'll say is that sometimes people want to be nice when they write these things up. And this is not the circumstance. You'd be nice in other times. But when you're writing a disciplinary letter, it's important to use direct language, not abusive language, but direct language. And what I often see is the passive voice as a way to soften it, such as, it was noted that the purpose of the lesson was not clear. And that conveys an impression that these events kind of fall from heaven. We're just helpless people who things happen to. And so that particular phraseology, it was noted that the purpose of the lesson was not clear, could well better be written, you failed to make the purpose of the lesson clear. And you words telling the employee what he or she did do and didn't do, as opposed to what happened in a passive way, is an important part of writing an effective disciplinary letter. So with that, we hope that's a helpful pep talk, and we'll turn to question 6, which Natalia will answer.
One of our coaches swore at student athletes, and we gave him a written warning. Now, a local reporter has asked for the disciplinary letter of our quote interview notes. Can we deny the request on the basis that is a confidential personnel matter? So we all struggle to address personnel matters, particularly when the media is involved, because we always want to make sure that we are sensitive with respect to circumstances in which students are at issue. And we also want to be sensitive to the confidentiality and the privacy of our employees. But that being said, there is just no way you're going to be able to keep the letter you wrote to the coach confidential. And that's because disciplinary letters concerning public employees are subject to public disclosure. But just to be sure, let me just clarify one point, and that is records of teacher performance and evaluation are not considered public records. I'm sure some of you who regularly evaluate teachers will probably, get chastised if you suggested that you were going to turn over a teacher evaluation. So teacher performance and evaluation records are not considered public records, and any other records related to the teacher evaluation cannot be disclosed without the permission of the affected teacher. But with respect to this letter, it's a disciplinary letter, and it can be because in 2002, the statute was amended to further provide the records of the personal misconduct of a teacher shall be deemed to be public records and shall be subject to public disclosure pursuant to the Freedom of Information Act. So whenever we have a disciplinary letter of other public employees, they've always been subject to public disclosure, and this particular coach may or may not be a teacher. In some circumstances they are, so we just wanted to highlight that one piece, that even though generally performance and evaluation records of teachers are not public records, disciplinary records of a teacher are. So if this coach is a teacher, the disciplinary letter is subject to disclosure, and if the coach is not a teacher, similarly, because he is a public employee, it will be subject to disclosure. So with respect to the investigation notes, however, the question of whether the public has access depends on some additional facts. And whenever we would be answering this question, we would be asking additional questions to sort of tease out those facts. For example, were the notes maintained confidentially as personal memory notes? Have they been shared with anyone, right? Have you kept them in your super secret drawer that nobody ever goes in? Because as we discussed earlier, personal memory notes can be considered to be preliminary drafts or notes, and those can be maintained confidential and nobody can pry them from your hands. But if you have shared those notes with others, then they're not going to be considered preliminary anymore, and they're going to be subject to public disclosure. I had a circumstance in which we initially claimed that some of the notes that were being requested were maintained as memory notes, only to find out that they have been sent to a colleague just to say, oh my God, can you believe the interview I just sat through today? And so in that circumstance, they're no longer memory notes, and they would be subject to disclosure. So be very careful where you keep all of these. But the last thing I'll say is that a report summarizing the findings of the investigation will be typically subject to public disclosure. And that's because under the Perkins test, which we've talked about in other webinars, which is a Connecticut Supreme Court decision from 1993, records related to personnel are subject to public disclosure unless there is no public interest in the information, and the release of that information would be highly offensive to a reasonable person. But in this instance, I think that there would certainly be public interest in the outcome of an investigation of public employees, and so the report will be subject to public disclosure. Now, that being said, there are times where you ask us to come in and conduct an investigation and put together a written report that often includes some legal advice, and that report will typically be considered an attorney-client communication and can be kept confidential. But as a matter of practice, it's important that we know where we store all of our information, and to recognize that disciplinary letters and those investigation reports are going to have to be turned over. So, watch out for tone as you're writing these.
Natalia, there's a follow-up. If a parent, in that previous example that Tom spoke about, the teacher who left the class unsupervised and then a disciplinary letter was written, if a parent asked for a copy of that, would it have to be provided?
Yes, but let me just clarify further, if I may, a little bit, because under the Freedom of Information Act, any member of the public can ask for responsive records to their request, but they don't necessarily have a right to give you 20 different questions and say, answer every single question. If we have responsive records that answer those questions, then yes. So if the parent says, oh, give me the scoop, like what happened, like this was really troubling to me, you don't necessarily have to engage in that conversation. And in fact, you shouldn't engage in that conversation. But if they ask for a copy of the disciplinary letter, it is a public record and subject to disclosure. I don't know whether Tom has anything else to add, but I often find that in Freedom of Information questions, some people rely heavily on the Freedom of Information Act and give you, like 100-page question summary and say, give me, responsive questions to all of, responsive answers to all of these questions. And that's just, we also don't have to create documents if none exists, right? So to the extent that a document doesn't exist that answers a Freedom of Information request, we don't have to create it.
Can I just follow up out of my own curiosity, in this instance with this question where the local reporter asks for the letter, is simply asking for it, or can you say, well, I'm going to make, kind of make you work for it, so to speak, and file a formal request? Couldn't they say, give me copies of all the discipline letters you've written to teachers or coaches this year? Or, I guess how responsive do you have to be?
So it's a very good question. And I'll give sort of my 2 cents, and then I'll ask Tom to elaborate if he feels the need to. But typically we receive these requests in written form via email. The reporter will say, can you tell me, give me all of the disciplinary letters that you've issued from September 1st to January 25th. And so we'll turn them over, right? And we don't make people specifically say pursuant to the Freedom of Information Act, because they're not required to do that, right? We understand that that's what they're asking for and that they're entitled to it under the law. But I have heard that some districts have said, nope, there's a formal FY process. You have to follow this process, and otherwise you don't get it. Our recommendation is that it is considered a request under the Freedom of Information Act. It is a written request, and so that you should honor that request. But Tom, I don't know whether you wanted to add any questions.
I just want to congratulate you on giving good advice, because the Freedom of Information Commission has explicitly ruled that a request for information does not need to invoke the Freedom of Information law. But there is so they say, please give me a copy of X. You have to give them a copy, but there's a little subtlety to that as well. And that is that people have the right to inspect public records at reasonable times. But if they want a copy, you have the right to ask for them to ask for that in writing, so that their request for a copy is documented. And then we have the record to show whether the response to the request was prompt. But we increasingly see ambitious reporters looking for something to write about, and they make these requests, and we have to turn that over. So whenever we write a disciplinary letter, no matter what our mood is when we're writing it, we have to remember that it can be in the newspaper the next day. So you want to be as unexciting as possible in describing the misconduct, and sometimes less is more. So
we
with
have
that,
we have a related question that I think is actually very
Okay.
interesting, which is if we give a verbal warning to a teacher regarding a disciplinary infraction and the parent requests the information, but the warning was verbal, how do you proceed? Right. I would respond the way I would respond typically to a Freedom of Information request that seeks that information, by saying that there are no responsive records to that question. In other words, you don't have to create a record that codifies the verbal warning that you gave the teacher. If there is one, if there is an email which you said, I just want to confirm the conversation we had today at 3:45, in which I gave you a verbal warning for being late to your 5th period class, right? Then if that exists, then that is a disciplinary record subject to disclosure. But if that doesn't exist, you don't have to create it, and you can simply say that there are no responsive records to that request.
perfect. So on to question 7. My secretary keeps making mistakes, and this is a hypothetical situation. My assistant, who I think Natalia, and our assistant, I think, is watching, and we're not talking about her.
Definitely not, never.
Right. But in this hypothetical situation, the secretary keeps making mistakes. Finally, the supervisor sits her down to say she better improve or else. She grows indignant and says, well, I have diabetes, don't you? Confused, I ended the meeting. What should I have done? And I don't make this stuff up. This really happened. And so the answer is we have to be clear as to what the employee is telling us and why. We start with the question is, what is a disability? And in fact, diabetes is a disability. Under the ADA, a disability is defined as an impairment that substantially limits one or more major life activities, or having a record of such an impairment, or the employee being regarded as having such an impairment. In 2008, there were a number of Supreme Court cases limiting those concepts. And in 2008, Congress passed the ADA Amendments Act and instructed the courts that these terms should be interpreted broadly. And for example, in with the issue of diabetes, they included as a major life function the endocrine system. I'm not a doctor, but we typically don't want to fight the battle, although we can in an appropriate case, on whether an employee has a disability as defined by the ADA. But the real question is whether and how that disability affects the ability of the employee to do his or her job. And in that particular case, that superintendent, as the case was, should have said, timeout. Why are you telling me this? Are you telling me you have diabetes because you're making conversation? Or are you saying it affects your ability to do your job? If you're making conversation, I don't want to know. Your disability status is a private matter. I have no business-related need to know whether you have diabetes. But if you're telling me that your disability affects your ability to do your job, then the threshold question is, do I agree that there's a disability? And sometimes we even send people for an independent medical evaluation to see whether they have a disability. In this particular case, there'd be no point in doing that because presumably the secretary is under treatment and can easily send us documentation from her doctor that she is under treatment for diabetes. But that's the threshold question. So is there a disability? Is there some disability that substantially impairs a major life function? Once we agree one way or the other that there's a disability, then the question is, how does that disability affect the employee's ability to do his or her job? And to the extent it does affect one's ability, whether and how we can accommodate that disability. And the ADA describes that process as an interactive dialogue. And those are important words. In other words, that conversation about whether and how a disability affects a person's ability to do the job should involve not only talking, but listening and hearing from the employee and engaging in a problem-solving exercise. But what are reasonable accommodations? Well, that will depend entirely on the circumstances, although I think sometimes people are surprised at what might be expected by way of an accommodation. But the critically important point here is that employers have the absolute right to have employees perform the essential duties of the job in a satisfactory way. So, for example, what are the essential duties of a teacher? Cognition, organization, planning, speaking. And if a disability prevents a person from effectively teaching, well, that's very sad. And we consider whether and how we can accommodate. But if, irrespective of whatever accommodations we offer, a person still cannot teach effectively or effectively clean a building if it's a custodian, then they're not able to perform the essential duties of the job. That distinction goes back to the very beginning of disability law. In 1973, Congress passed Section 504 of the Rehabilitation Act, which in 1990 was incorporated in a broader prohibition against disability discrimination. But from its inception, Section 504 said that no otherwise qualified individual with a disability shall be subject to discrimination. That otherwise qualified means that they have to be able to perform the essential duties of the job. And if they're not able to perform the essential duties of the job, then it's not discriminatory to say that, I'm sorry, but we're going to have to terminate your employment. So that's, I think there might have been some questions, Bill, were there?
Yes. Yes, there's one question, kind of combines a couple different issues. If you have a teacher, you're working with a teacher on progressive discipline for inappropriate behavior demonstrated by that teacher in a classroom, parents begin asking questions about the situation based on what their children are telling them when they come home. How does the administrator respond to the parents? What can the administrator share or not share?
Well, that's complicated, but a really good question that will be driven by the facts, but I won't duck the question entirely. It's awkward, but when a teacher's on a plan, that is confidential information under 10151C, and you're not even supposed to tell other teacher colleagues unless they're part of the plan, let alone parents. So This is where you summon your charm and you tell the teacher, I'm sorry, the parent, that we're aware of the concerns. We're working with the teacher. And if your child has any other concerns that you think we should know about, please let us know. But these issues of supervision are not subject to public discussion. And so that's, I think, the best we can do. And so let's move on to question 8, which Natalia will address.
Okay. A custodian continues to cause trouble even after suspension and 2 written warnings. I am ready to recommend that he be fired, but the union representative asking me to consider a last chance agreement. What is that, and are such agreements advisable? So as always, the answer is it depends, right? Because last chance agreements can be an appropriate way by which employers can give a problematic employee a final opportunity to perform successfully. And so the essence of the agreement is that the employee waives his or her right to challenge the termination decision if the employee again engages in the same type of prohibited behavior. So it might be helpful to review the elements and the mechanics of the agreements. And so we're going to go through them just ever so slightly. But the agreements are used only for unionized employees who may challenge the termination of employment through the grievance procedure. Final warnings are also appropriate for non-union employees, sort of like in a parallel track, but the formality of this last chance agreement with time limitations and procedures for challenge is not really necessary for non-union employees. So the first thing that's important to remember is that you have to be specific as to the misconduct that will trigger termination of employment in accordance with this last chance agreement. What that means is you have to specifically identify the conduct for which they're being disciplined and clarify that if that conduct reoccurs, you will be terminated. So for example, if the reason for the last chance agreement is habitual tardiness, like we talked about with our paraprofessional before, then that should be stated. And if the employee commits a different offense, then that would be completely separate and it wouldn't trigger termination under this last chance agreement. And so it's very important that we are precise with our words in drafting these agreements, of course, to the extent that we can be, because that triggering conduct is important. The other thing that's worth noting is that in order for these to be enforceable, the agreement, this last chance agreement, has to be time limited. As a matter of public policy, an arbitrator or a judge could very easily rule that the last chance agreement that has an infinite duration is not enforceable. And so it's very important to determine a reasonable period to keep somebody on the hook, so to speak, with this last chance agreement. So typically we do it for 2 or 3 years. And after those 2 or 3 years, we write in there that once the effective period expires, the last chance agreement remains part of the employee's disciplinary history, right? So the third thing that we want to mention is the last chance agreements provides that the employee's employment will terminate if the employee engages in the prohibited conduct. In other words, you identify the triggering conduct, you say for how long this person's on the hook, and then you say, if you do this again, you're going to be fired, right? But you really need to clarify the prohibited conduct within those last chance agreements in order for it to be triggered effectively. So the one thing that's important to also note is that last chance agreements typically do not leave the decision of this triggering conduct solely to the employer to determine. But instead, the last chance agreement typically provides that the employee can challenge the determination through some sort of grievance procedure, and that's outlined in the last chance agreement, with the understanding that termination will follow if the conduct is confirmed through this grievance review. And so if and while the employee challenges the employee's factual claim that it did or did not happen, then the last chance agreement also typically provides that the employee will remain on an unpaid leave. In other words, if you do this conduct again, then you will be terminated, but the employee has a chance to challenge it, but that employee will be placed on unpaid leave during the pendency of that review and determination. So if the employer's claim that the misconduct has reoccurred is not confirmed, then typically the employee is going to be restored to employment with full back pay. So, it could be dicey in that respect. So if the employer and the union, the employee and the union can agree on the terms of the last chance agreement, they can be very helpful, particularly in circumstances where somebody's doing the same thing over and over again and everyone's just had it. So if the employee is unable to refrain from doing what we allege that the person has done, in this case, habitual tardiness, then termination is just going to simply follow without the burden of a grievance arbitration hearing that we would have to engage in, if the union challenged that termination. So by contrast, if the employee is able to meet the requirements of the last chance agreement, then the agreement works, right? And the agreements provide sort of an opportunity for rehabilitation and for continued employment, which goes back to my original sort of comment that a discipline should not be punitive, rather, but it should rather support the employee to become a better employee and to correct the misconduct that they have exhibited. So with that, I will turn it over to Tom, since I am trying to be mindful of time and we have 2 more questions.
Question 9. A school secretary has complained that she's been paid at the wrong rate ever since she was hired 3 years ago. She is correct, and she's demanding a pay adjustment for the whole time. Should we give it to her? This is a great question. Sadly, it's also a common circumstance because mistakes happen. But we have to start in this situation, and in any situation where an employee has a complaint, by asking whether it's a grievance under the collective bargaining agreement. And every collective bargaining agreement defines a grievance and has a grievance procedure. And a good definition is an alleged violation, misapplication, or misinterpretation of a specific provision of this agreement. But unfortunately, some collective bargaining agreements define grievance more broadly. Some really bad agreements say a complaint by an employee, and then they're able to adjudicate their complaint through the grievance procedure. But most contracts do refer specifically to the contract terms. And so now, if we concede, as we would in this case, that this is a grievance because the employee is complaining about the pay scale, which is right in the contract, then we have to then ask the question, well, what are the grievance timelines? Well, two things. First, if this happened 3 years ago, and let's say it was a letter of reprimand when the employee was hired, or something that happened then we would say, well, that's untimely because all grievance procedures have timelines. In this particular case, though, this employee would correctly claim that she has what we call a continuing grievance. That is, that every time she's paid at the wrong rate, that's a new event that warrants a review under the grievance procedure. So with her continuing grievance, she would have a claim that that her pay should be corrected. But the remedy in that circumstance would depend upon when and how the employee filed a formal grievance. And any liability that falls outside that timeline, let's say that the employee should have filed for the grievance she should have filed her grievance within 10 school days of the event or condition giving rise to the grievance. Well, then we'd be on the hook for going back 10 days and then going forward until we corrected the mistake. In many circumstances, boards of ed that make these mistakes might be willing to go back to the beginning of the then fiscal year and correcting it from there. But that would be a courtesy because you have a grievance only in accordance with the timeline. And if a school district extends that courtesy and says, well, sorry about that, and we'll go back to July 1 to correct this, it would be important to get an agreement from the union that courtesy would not establish a past practice. so that you could deal with future situations on their own merits. And finally, since we're talking about grievance procedures, I just want to caution everybody that it's really, really, really important for a frontline supervisor not to just grant a grievance, because grievance settlements, even at the lowest level, are binding upon the employer. And the labor board has decided cases where the frontline supervisor says, oh, you're right, you should have had that as a holiday, and is wrong. And then they wake up and they say, oh, no, that's wrong. And the labor board said, hey, you settled the grievance. That's how it's been resolved. So even the first level of a grievance procedure should involve a conversation with HR and the administration, the central office, so that everyone's in agreement on what the appropriate response is. And we should never leave frontline supervisors free to decide whatever they want at step one, because it can be a problem later on. So with that, Natalia, we're coming around the bend here toward the end, and you have question 10.
Thank you, Tom. A student claimed that a teacher pushed him into the wall. We filed a report with DCF and put the teacher on leave. DCF took the case, but it's taken forever to complete the investigation. Can we go ahead and do our own investigation? And the answer is eventually, because the school district will be able to do its own investigation for sure, but we need to make sure that it does so appropriately and at the right time. And what I mean by that is that there is a statute that sets forth the obligations of both DCF, any law enforcement agency, and the board, well, the school district. And so before we undertake any investigation of DCF matters, we have to coordinate with the Department of Children and Families and get their permission to proceed with its own investigation. And that's because 10-221S imparts on us the obligation to conduct the investigation, but only after we get permission to proceed and confirm from DCF that we're not going to interfere in any way with their investigation or with the police officers, right? So in the statute, it says the school districts have to give priority to any investigation of abuse or neglect by the Department of Children and Families or by a law enforcement agency. It also affirmatively states that school districts have to conduct their own investigation, but only after receiving notification from DCF or the police that we're not going to interfere. And then following that investigation, school districts have to take disciplinary action in accordance with statute, right? And so in reviewing that particular statute, which is 17A-101I, we just want to highlight that if DCF substantiates abuse or neglect, and the commissioner recommends that the employee be placed on the central registry, or if DCF determines that a school employee has victimized its student, and there's a particular definition to victimization, then the school district has to suspend the employee. One of the questions we regularly get is, can we put them out on leave? Do we suspend them? What do we do? Right? And the answer is, you don't have to do anything except at that point in time when DCF determines that there was abuse or neglect and that person is placed on the registry, and then you have to suspend them, right? And any suspension, I'm sorry, has to be with pay and without prejudice until action is taken on that employee's employment. And we always talk about that in the context of disciplinary actions. When we put somebody out on leave, it is with pay and without prejudice. It is not a disciplinary decision. It is simply a decision that's made in the course of potential disciplinary action. So it's important that we remember that those suspensions are with pay and without prejudice until we take further action with respect to the employee's employment, and whether termination by the superintendent of a non-certified employee, for example, is going to happen is one thing, and also in the context of certified employees, whether the Board of Education determines the termination is appropriate. So in the case of a certified employee being suspended, the superintendent has to notify the Board of Education and the Commissioner of Education within 72 hours of the suspension. And it has to tell them the reasons for the suspension. I'm sorry. And don't worry about writing this all down because it will be in your packet, but there are some time-specific requirements in 17A-101I that contemplate this world of disciplinary action in the course of a DCF investigation. And the statute contemplates also that any certified employee will be terminated in accordance with the Teacher Tenure Act, providing that in that act provides a suspension of a teacher employee employed in a position requiring a certificate shall remain in effect until the Board of Education acts pursuant to the provisions of 10-151, which Tom mentioned earlier. So the superintendent is also required in these instances to disclose records of the investigations of that certified employee to the Commissioner of Education and also to the Board of Education or its attorney for purposes of reviewing whether the employee's employment is at issue and whether the certification must be revoked. You might be familiar that in circumstances in which significant abuse or neglect has occurred and is substantiated by DCF, and even in cases when DCF doesn't really substantiate, we internally take a deep review of the circumstances and determine what, if any, recommendation for termination or other discipline is appropriate. So if the contract of the employee is terminated, of that certified school employee, or if the certified employee resigns, then the superintendent has to notify the Commissioner of Ed within 72 hours as well after the employee is terminated or has resigned. So finally, when the Commissioner of Education receives the notification, then they start this whole process of certification revocation, which you may or may not be familiar with, and then with the sort of understanding that any information received by the Commissioner or the representative pursuant to the statutory process is confidential and is not going to be subject to disclosure under FOIA. But what's critically important is that we need to remember in the context of disciplinary actions that the statute 17A-101I specifically prohibits boards of education from employing a person whose employment contract was terminated or who resigned from employment following a suspension pursuant to the statute if the person is then convicted or one of more crimes involving an act of child abuse or neglect. So in other words, if somebody decides to resign from their position, or if somebody is terminated from their position because of allegations of abuse or neglect that have been substantiated, and then there's a related criminal piece to that, then we're not permitted to hire them moving forward. So I think we have successfully finished with 2 minutes to spare, and I don't know if we want to answer one question that we have left, Bill.
There is, and you may have answered this, but just for clarification, it says if a DCF referral is filed on a teacher, should the teacher automatically be put on leave while it is being investigated? And then it says even if the referral is non-emergent. So
well, I appreciate that. Yeah, I appreciate the question and the opportunity to answer it, because the answer is it depends. It's a business judgment. And different boards of education have different appetites for risk. Some boards of education take the position that anybody that gets reported to DCF goes out on leave. Other boards of education take a longer process. And so it's really, there's no right or wrong answer. There's no specific requirement that people be placed on leave, but there are circumstances sometimes that require that people be placed on administrative leave. And that is not only in the best interest of the Board of Education or the superintendent, it's really in the best interest of the employee as well, because during the pendency of these investigations, it's an uncomfortable place to be, and there are rumors and there are interviews that are taking place. And so I think it benefits not only, we tend to, employees that are being placed on leave tend to look at this as a punitive decision, but sometimes it's actually a proactive measure taken to ensure the safety of the employee.
Well, that's a terrific response, and you are experts at managing your time and the time of all of us, because we're right at the end. So I want to thank both of you, Tom and Natalia, for being here today and sharing your expertise and wisdom with all of us. Wonderful presentation, and I do want to remind people we'll be sharing the recording and these materials with you. I want to thank CAS's corporate partners, the College Funding Coach, Horace Mann, Jostens, and MCM Fundraising for their support of professional development for Connecticut's school leaders. And of course, I want to thank everyone in the audience for attending. We will have some CAS programs coming up next month, February 1st, 9:30 a.m., hosting a webinar with representatives from Ed Curation, who will speak about evaluating high-quality instructional materials. And on February 15th at 4 p.m., we welcome back Dr. Bill Summers, who will be discussing emotional anorexia. See our weekly news blast. In addition to getting Tom's legal mailbag column, we have information on all our CAS events and activities also on our CAS-CIAC.org website. So again, thank you, Tom and Natalia. Terrific presentation. Thank you, everybody, for joining us. Look out for your materials, the recording, PowerPoint, and handouts. And on behalf of all of us at CAS, I wish you well. Have a great end to your day, wonderful evening, and a great rest of your week. Thanks, everybody.